What's going on, Dominators? Rico Garcia here, and back with yet another episode. Today, we're going to be talking with Ali, an attorney, and I think this is a really interesting episode because today what we're going to be talking about is a lot of the dynamics of what's been happening with, the AOBs here in Florida, contracts in Florida, the removal of attorney fees in Florida, and more importantly, how this all really affects us restoration contractors. This is a really informative show. I think that there's going to be some massive takeaways. And more importantly, you kind of get a little bit of a view of the landscape and also what's going to be potentially happening in the future. Because again, these things just really never stay still. There's always going to be made some amendments that are made to legislation. And there's always going to be this battle to pay out less and to have insurance companies save more. And Ali really puts a lot of things in perspective in this particular podcast. So without further ado, let's jump into the show. Hope you enjoy. Let's go.
Welcome to the Restoration Domination podcast, where you learn actionable advice that moves the needle and helps service-based businesses dominate. Here's your host, Rico Garcia Jr.
All right, Dominators, let's get ready to buckle in. First and foremost, Ali, man, thank you so much for jumping on the show today. Are you ready to help us dominate?
Of course, definitely.
Let's do it. So I'm really excited about this conversation because especially if you are a restoration contractor in the Florida area, which just so happens to be where I'm located at, this is going to be one of those interesting topics that is a concern for a lot of restoration contractors, right? So hopefully today you're going to be able to answer some of these questions for us. But before we do that, do me a favor, fill in some of the gaps on my intro. Let everybody know exactly who you are and what it is that you do.
Okay. I'm an attorney. I've been practicing law since 2006. I represent just homeowners, property owners, commercial business owners against insurance companies for property damage claims like Hurricane Ian, Hurricane Nicole, storms, the crazy hailstorms that we just had the other a week. I represent basically policyholders against insurance companies in lawsuits. I've been doing this now for a little bit over 5 years. On the plaintiff side as a partner in this law firm. Prior to that, I was in-house as an attorney for State Farm. I did a couple of trials with them. Prior to that, I worked for several defense law firms on the other side. So I was on the defense side for almost 8-9 years, defending, I would say probably like 80% of insurance companies in the state. So I eventually flipped sides and, became a partner in this firm. I started out my career as a prosecutor, a criminal prosecutor, felony prosecutor. And I had over 50 trials as a felony prosecutor. Then eventually I made the switch to insurance defense and then eventually switched to becoming a partner in this firm. Since I've left State Farm, we've been just having wonderful results. My office, I'm the managing partner of my office, has gone from 1 attorney to now 7 attorneys. Went from basically just me and 1 paralegal to now 17 people, 16 to 17 people just in my office.
That's awesome.
The name of the firm is Kuhn Raslovich. We have 3 offices. My office is in Altamont Springs, Orlando area. There's an office in Tampa, and then there's an office in Boca Raton. But I'm basically the managing partner of my office in Altamont, which is North Orlando, what people like to say. And I've been, at this office now for, a few years. And I love what I do. I love taking depositions. I'm a child attorney by nature, as a prosecutor. So I like taking depositions. I like going to trials. Unfortunately, I haven't gone to trial yet since I've left State Farm. But that's not because we haven't got the results that we wanted. We've gotten close, like the eve of trial, but then the case settles. But that means we're doing our job,
Right.
Most people don't want to go to trial. They want to get paid, the right amount of money instead of going to trial, right? In lieu of trial.
Exactly.
And we've been successful at it now. And, I love what I do. I work with a lot of public adjusters. I work with contractors. And, I use my experience on the defense side to my best advantage.
How much of a home court advantage does that actually give someone that has that experience, right? Because I think that sometimes this is overlooked when, especially like as a restoration contractor, right? A lot of us think, oh, it's like an attorney's an attorney, but there's got to be some home court advantage to someone who's actually been on the defense side for the insurance carriers. I mean, what do you personally think is like your advantage by having that experience under your belt?
You know how the opponent works. I mean, you basically were the opponent for almost a decade. You know internally what makes things work there, what makes things settle, how the insurance company works, how they evaluate a case or claim. And I did both. I was in-house. I did first party damage work for State Farm and third party injury work. So I did both. But the first party work, a lot of people don't get to do that in-house for insurance companies. And it's really interesting. What you really learn is because, they only let you use certain engineers. They don't let you use certain independent adjusting firms. And the reason why is because they have agreements with these companies. And these companies issue the reports that they need to either deny claims or lowball claims. It's very rare you see an engineer go out there on behalf of an insurance company really objectively analyze the claim. He's out there to either deny your claim, to provide facts to deny your claim, or to lowball your claim. I'm just telling you. And there's a Rolodex of only certain engineers you can use if you're an attorney for insurance companies. That's how the game works.
Is this conspiracy theory, or is this like, hey, firsthand, this is what you saw happen?
This is not conspiracy. This is reality, and that's why I file CRNs in every claim, because their business model is unethical. In my opinion, it's not handling your case in good faith. It's not, it's not. They're in essence committing bad faith when they hire, an independent adjusting firm that they have $1 million relationship with, who's going to go out there and not investigate the claim properly. Well, you know what's going to happen? Your claim's going to get denied, all right? Or it's going to get lowballed, one of the two. Or if they hire an engineering firm that they have multi-million-dollar relationships with, what do you think the engineer is going to do? He's going to go out there to give them facts to deny the claim. I'm as a trial attorney, I take depositions all day long, and this is what I see all the time. It's very rare. Like, for example, Rimkus has a multi-million-dollar, over $30 million relationship with Liberty Mutual. In Florida, they're known as the First Liberty, a subsidiary, okay? They like to do that, the big insurance companies. They like to disguise themselves in Florida as like a small player, but reality, they are the big player. Like, for example, Castle Key is Allstate. Don't get it twisted. It's not no small company, okay? And the First Liberty is not some small company. That's Liberty Mutual with deep pockets. A Geico worked with UPC, and UPC just went bankrupt. People need to look at this stuff and be like, yo, wait a minute. How is this the preferred company for Geico, but they're going bankrupt, and Geico's flush with cash?
Right.
I'm just saying. But, you look at a company like, First Liberty. I took Liberty Mutual. I took, one of their Rimkus engineers' depositions. And through discovery, I learned, over $30 million relationship that they've been paid throughout the course of their, business relationship, Rimkus and Liberty Mutual. They're hired guns. The contractor that they hired was paid over $4 million. That's a hired gun.
Right.
My engineer, my contractor, has been hired by my client for the first time. First time. That's it.
Right.
The jury will hear, like, what we fight tooth and nail as a trial attorney is that you want a jury to hear about the relationship that they have with their experts, with their witnesses, because that tells you that they have tunnel vision when they're adjusting your claim. They're not adjusting your claim trying to find out whether there's coverage or not, whether they really want to make you back, make you whole, put you back in pre-loss condition. They're really going out there to deny your claim and to minimize your loss. And they say something like only 10% of people challenge claim decisions. It's usually the people that get a public adjuster or get an attorney. 90% of people, something like that, accept the claim decision that their insurance companies make. So that's a great business model for an insurance company, right? You know that 90% of people are not going to question your decision, and you're going to hire guys out there that are going to do everything to deny the claim or to lowball it. Well, that you're going to make a ton of money.
Right.
That's the business model for these insurance companies. And that's why I file a bad faith complaint in almost every claim, and point that out every single time. And that's how I litigate my cases. When I take the field adjuster's deposition, I want to know how much that field adjuster was paid. How many claims he handled for this insurance company? For how long? The extent? How many years have you worked with this insurance company? If not this insurance company, what other insurance companies have you worked with? And if you just work with insurance companies and never for the policyholder, how are you really fair?
Right. Are you biased, right? Do you
How
have
are
this built-in bias, right?
Sure. And that's what we use that when we get to trial, that's how we impeach their witnesses. When I was at State Farm and I went to trial a couple of times on injury cases, our doctors that we use, we paid like $3 million in the past like 4 years. That evidence came in at trial. Well, you know what? Their doctor wasn't paid anything. All they hear is that he's got a letter of protection, right? And he says, well, the reason I give a letter of protection is because this person can't afford my treatment. And I still want to treat them. So I do it for free. So I get paid when the case settles. That's not unreasonable. That actually makes him look like a good guy, right? That they're helping a broke person out. The reality is that if you're a really good plaintiff's attorney, you go into those relationships deeply when you're trying the cases. And that at the end of the day is what helps you win the trial. And on top of all the things that they're not doing, right? Because when you work for them, you know that they're not getting a plumber. They're not getting a leak detection company with the camera through the lines to see whether the cast iron line is really collapsed or not. They're not doing that. They really aren't. They're not going to do that. They're going to ignore that. Their engineer is never going to ask for pre-loss photographs or for the underwriting file to see what the condition of the home is before the loss. Reason why is because it supports our case. Because if it shows no damage, that means it corroborates that the damage that my client's claiming is due to the storm, right? Because if you see there's no damage prior to the storm, then obviously my client's proven their case. Well, their engineer is never going to ask for those photographs. Is never going to pre-loss photographs, underwriting photographs. They're never underwriting reports documenting the condition of the property. They intentionally ignore that stuff, and they know that stuff exists, and they ignore it. And you confront it with them at their deposition. And how you do it is then you ask them, "Hey, how come you didn't ask for pre-loss photographs?" And they'll say, "Hey, why do I need to do that?" I go, "Don't you think pre-loss photographs are going to help you?" And they go, "Why would they help me? I'm just trying to figure out what the cause of loss is, right? Cause and origin. That's what they'll say. Cause and origin. The cause of the damage, right? And the extent, the origin of the damage and the extent of damage. That's really what their engineers are saying. So then you keep going with the questions and you're like, well, if you had photographs showing the same damage, right, prior to the date of loss, wouldn't that help you determine whether the damage is related to the storm that my client's claiming? And they'll say, of course it does. It proves that it's not related, right? It's the same damage before the storm, after, so it can't be. I go, so then on the flip side, if you had photographs showing no damage prior to the storm, would it then corroborate that the damage was most likely related to the storm? You know what you hear? I don't know.
It's crickets, right? Like all of a sudden,
it's like I don't know.
is out the window. But listen, I want to stop you right there for a second because you mentioned something, and I want to go ahead and shine a little bit of light on it, which is the CRN. And I always hate using acronyms because some people don't know what it is, and then it flies over
bad faith complaint.
Yeah. So let's talk about that, right? It's a civil remedy notice, right? Officially,
Correct.
Right? The civil remedy notice, the CRN. Let's talk about that. Who can file it? Because again, and I want to touch on this because I think that there may or may not, and you will clarify this, based on the new landscape in Florida with attorney fees basically out the window now, I think that this may or may not, and you will correct me on this, to be just an additional tool in the arsenal that perhaps, from my understanding, anybody can file a CRN.
Yes.
Okay.
So one good thing about all this stuff, they got rid of the attorney fee statute for all insurance claims in Florida. All. So whether it's property, PIP, right, personal injury protection, whatever, health insurance, you contesting a health insurance claim denial, you're not going to get attorney's fees if you're a policyholder and you need to sue the insurance company to challenge the claim. So it's going to cost you. You're going to have to pay out of your pocket to hire an attorney to go after the insurance company, and that's what getting rid of the attorney fee statute really did. It really didn't hurt attorneys. I get that's how the insurance company loved to portray it. Oh, these attorneys are milking the system, making money off the attorney's fees. The reality is that if we're all corrupt and we're all bad, we're all like, who do they like to show? The poster boy, Scott Strems, right? They like to, if we're all Scott Strems, our legal system wouldn't work. Our judge would dismiss every case. I wouldn't make any money, like the reality is majority, if not all attorneys, are not doing that stuff. And, the bad faith statute still has attorney's fees built into it. And they haven't got rid of that statute. As long as that statute is still in place in Florida, that's what really, in my opinion, holds insurance companies accountable. It's section 624.155. It's the bad faith statute with attorney's fees still built in. And that's what the CRN is, the civil remedy notice. It's based on that statute. So when you file that notice, you're still entitled to attorney's fees under that statute. It says it. So they haven't gotten rid of that. And insurance companies know that. So the fact is that I call it the Charlie, Brown, dark cloud over their head, the CRN. You file that right when you intend to initiate litigation. And that cloud hangs over their head as your lawsuit, progresses. If you have to file a lawsuit. Now we have to file what's called a notice of intent to initiate litigation. And if you're not able to resolve that, then you file the lawsuit. But the CRN, or the bad faith complaint, is hanging over their head the whole time. And they know that if they settle your lawsuit, they don't want a full release of everything. Bad faith, every claim under the sun, even though your lawsuit is not even for bad faith, but they still want a release for it because of that complaint. Mm-hmm. Because you know what? If you settle the claim with them and you don't give them a release, right, you can sue them for bad faith.
Wow.
So a lot of people don't know that. Right. So when I negotiate these cases and I settle, they're like, "Oh, we want to settle. Here's our offer." I go, "No problem," without a bad faith release. Mm-hmm. This is not a bad faith lawsuit. If you want a bad faith release, that's damages outside of the breach of contract lawsuit. That's punitive damage. That's compensatory damages, right? Outside of the contract. So you got to pay for that. There's attorney's fees built into that statute. So you got to pay for attorney's fees and you got to pay for extra damages if you want a full release. Mm-hmm. People that have been, if you've been litigating in this field for a long time, which I have been, in first party for over a decade, over 13 years now, that really the statute that carries weight at the end of the day is 624.155. As long as that's still there and the attorney fees is still built in, I'm not worried about it.
So now there's this chatter right now where it's the contractor now feels in the state of Florida that, hey, the insurance companies have a little bit more pull, or a lot more pull, depending on who you ask, because now a lot of attorneys are possibly not going to take some of the smaller claims. They're going to take some of the smaller claims that they normally would have, sat on their desks, and, eventually we know that this thing will settle out. So is that still the case? And because if it is, the restoration contractor has to learn to maneuver slightly differently, right? You're taking more of a cash pay model. Maybe you're taking more deposits up front. Like you got to figure something out, because if I was a carrier, right, and I know that now the deck is stacked in my favor a little bit more, then, and I'm already accustomed to, delay, then hell, now I've got more power to delay even more and put up all these roadblocks, because I know that if the restoration contractor tries to go back to his old attorney that handled all of their claims, well, you know what? The attorney fees are removed. Maybe the attorney isn't going to want to take that. So how does that really play out in the real world? If
you don't practice in this field, it can end you. If you don't know what you're doing, it can end your career as an attorney. But if you know what you're doing in this career, it doesn't end me. I'm just going to file a CRN and get my attorney's fees through that. And if you want to settle, well, you want a full release, well, you better pay for it. And you're right, though. There's going to be a lot of attorneys that won't take on cases, and there's no attorney fee statute. So, their business model is strictly based on the attorney fee statute. Well, if you know what you're doing, you know how to draft CRNs, you still get attorney's fees. And you need attorneys to draft CRNs. A lot of public adjusters don't want to draft them. The reality is that it's really the homeowner who drafts them, right? And a lot of public adjusters are scared because, they don't want to get charged with practicing law without a license. And I get the concern. I get it. The Department of Financial Services has come down on a couple of public adjusters that I know. I'm not going to say names or nothing like that. I know in the industry that they've sent letters and say, hey, why are you practicing law, filing CRNs? But the reality is, the CRN is from the homeowner. It's not from the PA. It's not from me. It's from the homeowner.
Right.
And if the homeowner wants the PA to sign it, or wants me to fill it out, it doesn't really matter. But I can see how that's considered practicing law.
It's
And
the
public
gray
adjusters.
area, right? It's open to
I can see that.
interpretation.
I can
Right.
see that.
Yeah.
And that's where attorneys, to me, like that, I'm going to use a CRN every time, and I'm entitled to fees as soon as I file that under that statute. And if you want to, so to me, I still think I'm still comfortable litigating these cases, handling smaller claims, doing all that because I know the law in Florida. I know how to do CRNs, bad faith complaints. Attorneys that don't know how to do that stuff will cave in. And
right. So I want to talk about exactly, because again, for the restoration contractor, I want to make this very clear, right? Because there's a lot of concern as restoration contractors, like I just stated, man, attorney fees are removed, right? There's been changes with the AOB. What kind of documentation should we use? Should we not use? If I have this claim that's not getting paid out on, and it does need to go to, an attorney, are they going to take my file or not? So I want to clarify what exactly this bad faith really is and how, from the lens of a contractor, how they should handle this. But before you answer that, let's just take a quick moment to thank our sponsors. Hey, Dominators, did you know that about 80% of businesses are actually unsellable? This is why you need to let Restoration Brokers of America work with you to ensure that you maximize the value of your business when you decide that it's time for a change. All you have to do is visit sellmyrestorationbusiness.com for more information. You've worked hard to build it. Now let RBA work hard to sell it. Hey, Dominator, did you know that it takes about 45 days for most contractors to get paid on emergency service jobs? And some contractors report much longer wait times than that. Either way, it's a long time, especially when you start adding in all of the stress that you have to do to keep up with payroll, overhead costs, and everything that goes along with just running a business. Well, One Claim Solutions is an insurance billing specialist that not only gets their clients paid in 32 days on average, but it also improves their profitability. And above and beyond that, it also handles all of the communications with the adjusters. One Claim Solutions was actually founded back in 2016. And since then, they've been able to process hundreds of millions of dollars in insurance invoices on behalf of their clients. Listen, you deserve to work with a specialist that has well-trained attorneys as well as staff. And also they have proprietary purpose-built technology with some really rigorous time-proven processes that's needed to deliver a best-in-class insurance billing experience. One Claim Solutions will handle it all so that you can focus on really what matters most, which is running your business. Head on over to oneclaimsolution.com/dominate. Again, that's oneclaimsolution.com/dominate. Book your free consultation today. Dominators, let's face it, your company will make it or break it on the backs of your estimating team. But if we're honest here for a second, what tools have you actually given them to succeed? The Actionable Profile is the newest tool inside of your estimator's toolbox, or at the very least, it should be. The Actionable Xactimate Profile is a data-driven solution that provides real-time estimating guidance on the fly. It checks for both overages, omissions in your estimates in real time, leading your team to having much more accurate scopes each and every single time that they're writing an estimate. Avoid any kind of potential conflict with the adjuster and ensure that your estimates include every single warranted line item with the Actionable Xactimate Profile. Get your free demo today. If you head on over to value.getinsights.org/dominate, we've got an amazing offer for you. Again, head on over to value.getinsights.org/dominate and get your free demo today. Hey, Dominators, quick question. Are you looking to attract top industry talent? Well, I'm here to tell you that Wylander is the go-to recruiting company in order to attract the best talent available inside of the restoration arena, period. Now, why do I say that? Well, simple. With over 1,000 placements, and more importantly, with experience in all 50 states, as well as in good old Canada, Wylander is going to be able to find the right fit for you and your company. Wylander not only has the expertise, but more importantly, they already have the connections to make sure that they find that perfect fit for you and your organization. So listen, we all know that time is money. So stop wasting time just sifting through resume after resume and let Wylander do the heavy lifting for you. Get back to what it is that you're good at. Get back to money-making activities. Call Wylander today. Let them help you find that next superstar in your organization. All righty, Dominators, we are back. So let's get into what really the bad faith thing is like, and what restoration contractors should understand, and perhaps make them feel a little bit more comfortable that the deck isn't totally stacked against them. Go ahead and shed some light on that.
Yeah, bad faith is really just an insurance company handling your claim, not looking out for your interests, and it can manifest itself in multiple ways. They could deny your claim, like I was telling you. And with the field adjuster and the tunnel vision engineers, they can delay your claim. They cannot respond to your communications. They can lowball your claim.
Give us some examples, some real life examples, some typical time frames of, because I think we've all, if you've been in this business for any kind of time, we've all sent out multiple emails that just we never get a response back.
Yeah, that 14 days.
Or they play that shuffle game. All of a sudden you're dealing with Betty and you don't get a response for 30, 60 days. And then Betty is no longer in that department. And now you're with Susie, and Susie, all of a sudden is taking a sabbatical. So we've all been there, right? So give us some time frame so we have an understanding of this.
So an insurance company has to respond to communication within 14 days. Mm-hmm. That's it. Simple as that. If they don't, they've committed bad faith. That starts the communication. They must make a claim decision within 90 days under the old statute.
Let me stop you right there and back up again, right? Because this is an important time frame. 14 days. Yes. 14 days from the day that the claim is filed.
No, the communication is made.
Okay, so now let's just so that we fully understand, right? Again, so kind of taking a step back, because you do this every day. I don't, right? I'm not an attorney, so this is just color by numbers for me, right? So does this clock start ticking, or does it reset every time that there is a communication? In other words, maybe you do receive a communication within the 14 days that view filing the claim, let's say, or sending the initial invoice. But now all of a sudden this person goes ghost. You've sent an email. They're not communicating with you for, let's say, 30 days. Did that secondary event reset that 14-day clock or no?
Well, okay. So let me break it down like this. They have 90 days to adjust your claim under the old statute. Mm-hmm. 60 days now. They just changed it. Okay. Now that's from the moment you report the claim. Okay. Unless there's factors beyond their control. The statute doesn't define what those factors are, but I'm just telling you what it says, okay? So 60 or 90 days, however you want to interpret the statute, because they just changed it. And then, unless there's factors out beyond your control. Now, but during the middle of your claim, right, you report your claim. You submit an estimate. You submit certain documents, whatever it is, an email. They have to respond within 14 business days to your email. Sworn proof of loss, it's 30 days. Mm-hmm. They must respond within 30 days to sworn proof of loss. The statute's on this. If they don't, they're committing bad faith by not responding timely. Can you file a bad faith complaint right off the bat? I mean, it's up to you guys. In my opinion, it depends on how bad of a delay and how it's impacting your case. I like, that's totally, I'll leave that to the discretion of the person. But me personally, I wait 90 days from the moment we report the claim. And if they don't make a claim decision, or they made a claim decision, I'm filing a CRN on the 91st day, no matter what. If they make a claim decision, then I'm filing my CRN then, whatever the claim decision that they make. Usually, I can tell you that it's maybe like 1% of time where a claim decision was made, like that made my client whole and they were happy. It's very rare to impossible.
That's the unicorn. That's the unicorn of the industry, right? Yeah.
So then you go ahead and, you just proceed with the claim, and, like if whatever they're doing, if they're sending multiple people out there, they're changing multiple adjusters, I consider that bad faith, because you have to start all over again and they're delaying the claim. The problem is the only insurance company you can't file a CRN against is Citizens, because they're the government. Mm-hmm. They've turned it, unfortunately, a lot of people in Florida have Citizens. So you can't do anything about that. The law is, you can't file a bad faith complaint against the government. But that's funny. It's because of that, Citizens does the shadiest stuff. It commits the most bad faith. Yeah. So, I would say, talk about changing adjusters on Citizens claims. you'll go through like 4 or 5 adjusters through the right life of a claim every single time.
Right.
And they won't, like a new one will come in, they have no idea what happened in the claim, and you start all over again. It's unfortunately it happens all the time with them. I used to do defense work for citizens, and I could speak to that doing defense work for them. How does this affect restoration companies and AOB companies? AOBs are no longer valid anymore.
Right.
So whether we like it or not, there's no legal standing for AOB companies now to go after insurance companies in Florida. You can't sue them anymore. It's over. Now, how do you guys get paid? You can do a letter of protection for the homeowner, and then the homeowner signs a letter of protection, making sure that you're protected if they have to, when they file their claim. But still, the recourse is through the homeowner. You depend on the homeowner, and unfortunately, if you don't get paid, you have to go after the homeowner. That's what they did. They by the AOB actually protects the homeowner, right? Because what it does is, let's say I'm a homeowner, right, and I don't want to sue insurance company, and I got this big bad windstorm, damaged my roof, have interior water damage, stains all over my ceilings. But man, I don't want to sue no insurance company, man. I don't want to go to take my depositions taken. I don't want to have a lawsuit on my record and have to go to court and, well, you can give an AOB to the contractor, who will then can sue the insurance company on your behalf.
Right.
And that gives you protects you, right? So you don't have to file a lawsuit. Now, they can always subpoena you for a deposition, obviously. Like, you can't change that. But the reality is that you're not in the lawsuit. Your contractor is. And, I think that protects you. That's a big headache that you don't have to deal with. Mm-hmm. And your contractor can. Now, at the same time, homeowners can say, I want control over my claim. Okay, well then don't do the assignment then. No one's forcing you to do the AOB. AOB is just an option. It's just giving you if you want to or not. To eliminate that, something that's been in our state for over 100 years, it actually hurts the homeowner, hurts the policyholder. It hurts the restoration company too, obviously, because there's no recourse against the insurance company. But it really hurts the homeowner, because then they can't hire the restoration company, right?
Right.
They can't hire
there's been a lot of chatter and a lot of different restoration contractors. A lot of them are still confused about what the proper set of documentation that provides them with the most amount of protection that puts them in the best possible position in the race to make sure that they can go after the insurance company to get paid. There's still a big debate about what these documents should be, what they should look like, what they should be called. Yeah. Help us out with that. Like, what, as a restoration contractor, what documents should we get?
Direction to pay, so that any payment that insurance company issues has to have you on it. Okay. Direction to pay, have the homeowner sign that, and a letter of protection. Mm-hmm. Have them sign a letter of protection saying that, they have to protect you when they submit your claim to the insurance company. Those two things are really the only way to right now to go about doing it. Yeah, you are at the you're in the hands of the insured. Whether you like it or not, the restoration company has to pretty much resolve their issues with the homeowner. If, for example, if your bill is very high and the homeowner doesn't agree, it doesn't want to get your bill paid, well, you better resolve that issue with the homeowner now. You can't go after the insurance company on your own, whether you like it or not. Right. So that takes that stuff away from you. So, from the restoration company. So you really got to make sure that the homeowner and you are on the same page, and that the homeowner respects your bill, right? And the work that you do. So I have like a couple of Ian claims where a lot of work was done. I'm talking about, you could argue over $100,000 worth of restoration was done. Now the homeowner's like, well, this is too much. And the restoration company's like, well, I could justify all these bills, but I'm willing to come down to resolve this, but I'm not going to shortchange myself and go broke. I have 5-6 guys that worked under me, to do this. So, but the homeowner and the restoration company are now kind of talking to each other and reaching an agreement. Oh, like, fine, we get it. All right, we admit that your invoice should get paid, for this much, and we'll make sure that, the settlement includes that, Right. Unfortunately, that's really that's all you can do at this point,
What else do you think? Kind of like forecasting here a little bit. I mean, obviously, this has been a very strategic set of plays that have happened within the insurance billing arena. What do you think is going to be happening in the future? I mean, what else do you think they're going to be trying to chip away at, or do you see the contractor potentially? Having some of the legislation go their way at any time in the future.
I think that they're going to try to go after public adjusters now. They're going to try to lower their fees. I think that they got everything what they wanted. They changed a law that was in place for 100 years, their attorney's fees, right to attorney's fees. It was in place for 100 years. AOBs, assignments, existed for almost 100 years in Florida. They got both eliminated in the span of 3 years. They won the war, man. They're winning. Insurance companies, they conducted a barrage campaign through the media. The Insurance Information Institute, this company acts like this. It's like this objective company that represents, a public interest company that just looks at the industry objectively. No, they're run by the insurance industry. Their members, if you look at their website, it's like 60 insurance companies represent them. And that company, the Insurance Information Institute, III, their spokesman is interviewed like in every like news piece that you see in the media. And this guy is so pro-insurance because he represents them that we only heard one side of the story through the media. That's why the statute got eliminated. They were successful in creating all this propaganda to convince that attorneys were making all this money when we really weren't, and to get rid of the stuff that actually protects the consumer, the homeowner in Florida. Now, the consumer and homeowner in Florida is up a shit's creek. I'm sorry, excuse my French, if they really need to sue an insurance company for damage to their home. Because find an attorney that's willing to take your case. If they don't have a statutory attorney's fees, it's going to be hard.
Right. Unless, of course, like you said, they're filing with the CRN and everything else, and they understand that, which kind of leads us back full circle, right? When we're looking at the players as far as attorneys are concerned, are there a lot of attorneys that are just not well versed in the bad faith aspect of it, filing the CRNs? Is this kind of like a mystical thing that because I know that I've had a lot of conversations with attorneys and they were freaking out. Contractors are freaking out. Everybody's freaking out. And you're kind of like sitting back and you're like, you know what, this isn't too bad. Like, it's really not changing my game a whole lot. So, is that like part of the secret sauce? Are we kind of like spilling the beans here, and the rest of the attorneys listening to the show is going to be like, oh, I get it now.
Well, CRNs is not, there's no template. It's either you know what you're doing to draft those or you don't. Mm-hmm. I learned through my experience, representing insurance companies for, over almost a decade, doing this work, learning all this stuff, knowing the relevant statute. There's the matching statute too that they haven't gotten rid of. That helps us. A lot of people don't know what that is. If you're well versed in the law, I'm not really that concerned.
Right.
I think, yes, it hurts. You're going to see a lot of attorneys fold, maybe law firms fold that don't know what they're doing. But the attorneys that do know what they're doing, understand the law, understand the statutes, I think we're going to be fine.
Different story for on the public adjuster side. You think that they're probably next on the chopping block, huh?
Well, because we were on the chopping block first, right? So I think it's just I think they already tried to introduce a bill to reduce their fee. I'm just saying everything that they're going to attack, they're attacking policyholders right now, homeowners. Right. We're the biggest advocates, attorneys, public adjusters, really. So they're trying to eliminate us, really. So the homeowner can't use us anymore. And
premiums are going up.
The insurance company.
Meanwhile, premiums are going up, and then the delays that are being experienced in, let's just take this last hurricane that just hit the west coast of Florida. I mean, they're like typically on projects that, tarping projects that people would normally get paid out on rather quickly. People are still waiting on money. Right. So talk to us a little bit about that. Like, what is this quote unquote, like perfect storm that's happened with the on the West Coast, and like what you believe has been part of this massive delay, why there's been such an issue with contractors collecting and everything else?
Nothing new. Unfortunately, this is how it's always been. When Hurricane Ian hit, I mean, no difference. I mean, delay. I mean, the triple Ds, right? Delay, deny, defend, right? And you're seeing it in South Florida. What now? Because when they passed the statute to get rid of attorney's fees, it's causing a lot of confusion to people. So a lot of people think, I can't get attorney's fees now because they passed the statute. Well, it's the attorney's fees is considered a substantive right, and the statute doesn't apply retroactively to a substantive right. So for Hurricane Ian, you're still entitled to attorney's fees. So I think they're okay, and they shouldn't have any problem. But the delay is still going to exist. That's how the insurance company does business. They hope you give up. They hope that you cave in and take nothing, because that's what people do. They can't stand people that are tough, that want to keep fighting them, that hire an attorney, hire a public adjuster, want to take depositions, that wants to push them to trial. They can't stand those people. Right. They'll pay those people in a heartbeat. Mm-hmm. They love the people that, I'm frustrated. I can't. I'm done. I'm giving up. It's over. You won.
Yeah, it's not worth it. Right.
That's not worth it. That's exactly what they're trying to do.
Right.
That's their MO.
Yeah. Right. Well, because they have the financial wherewithal to sit down, they're still sitting nice and fat. It doesn't matter. Right. But the homeowner, different story, right? Even the smaller contractor, different story. You got a $30,000 invoice out there. You're being offered 20. You've been waiting, 12 months for this money. You're like, you know what? Fine. And then you just, over on one deal, that doesn't really make a difference. But when you're talking about thousands and thousands and thousands and thousands of claims over, a period long enough, I mean, you're talking about big money, possibly in the billions, right?
Yeah. So what they're doing right now is they're basically doing what they always do. Their MO, delaying claims. They're going to underpay you, hope you don't challenge and give up first. I've never seen any of my Ian clients get paid fully off the bat. Every one of them, you've had to do something. Every single one of them. Not one single one has been made whole from the initial payment. I'm dead serious. And so then that forces you then to go after them. And luckily, the attorney fee statute's still there. So they can, but even without the attorney fee statute, I still think the bad faith statute is, with attorney's fees built in, is what still allows us to carry the day. But let's just go back to what they're doing out there, right? They're really delaying, and they hope all these people give up at some point, and boom, they're done, right? But the smart people get attorneys, get public adjusters that know what they're doing, and go after them and do not give up. And we'll listen to their attorney. We'll do the temporary repair, and we'll hold out so they get paid right, and compensated correctly. But some, they get so frustrated and they give up. I wish I could just tell these people, all of them, even the ones that give up, especially the ones that give up, that this is what they want you to do. That's why they're doing this. And when these pro-insurance laws get passed, the next hurricane that hits here, they're going to be able to do that without any consequence now.
Correct.
There's still a consequence to this right now. The attorney fee statute is still there. In my opinion, there's still a consequence with the CRN and bad faith statute, because I still know what I'm doing. But by passing or getting rid of, or passing these pro-insurance laws and get rid of the attorney's fees statute, the non-bad faith attorney fee statute, well, that just makes it easier for them. That allows them to delay things more. That make things harder for the homeowner to do anything to hold them accountable. But a smart public adjuster, smart attorney, still knows what they're doing, can still go after them. And it's very interesting. I bet you at some point they're going to try to go after the bad faith statute. They haven't touched it yet.
That was going to be my next question.
That is the last.
That was going to be my next question, right? Because you're kind of painting this picture, and it's like, well, great. Well, it's like this last wall of defense seems to really be written into law. Well, if they've made it this far, what's to stop them from going after bad faith in some degree? That's
what I'm scared of. They've amended the statute already twice. Recently, they added, like, for example, you used to be able to file CRNs. It didn't matter when. You could file them anytime during the life of the claim. Now you cannot file a CRN within 60 days of an appraisal demand. And the reason why they did that was because they were getting sued for bad faith. Because what would happen is that they would file the CRN and the appraisal award would never be issued within 60 days. It would always take longer than 60 days. Well, you have to cure the CRN within 60 days.
Right.
So then what would happen is the appraisal award would get issued, and then they get sued for bad faith because it would usually be a favorable appraisal award, right? Mm-hmm. Usually be more money than what the insurance company previously offered, right? That's a
Right.
favorable award. I'm just saying that that appraisal award shows that they committed bad faith by either lowballing the original claim, right?
Correct.
So
Right.
then,
It's
so
evidence
this
in
new
and of
statute,
itself.
they amended it by saying, well, 60 days, you can't do it now. So what that prevents is all those bad faith lawsuits from being filed now because you have to wait 60 days now when after the appraisal is demanded. Well, now that's kind of eliminated, right? So now you got to be extra careful when you file your CRN. I like to file it as early as possible before anyone can demand appraisal, right? Before the carrier, especially, right? Because if we demand it, we can't file a CRN either. We have to wait 60 days. So what I tell my clients is that you file your CRN, then demand appraisal.
It's a cat and mouse game. It's a cat and mouse game.
If you really want to go to appraisal.
Yeah, that
if
can
you want to go to
usually
appraisal.
be won, but you just have to have the patience and the intestinal fortitude, if you will, to play the game properly.
And appraisal is not good either. Appraisal takes the claim out of your attorney's hands and goes to an appraiser and then potentially to an umpire. And then they make the decision. If the umpire agrees with the other appraiser, usually on most policies, they can sign the appraisal award and you have to accept it.
Right.
So appraisal is not always a good thing. It's adversarial. It's expensive. The appraiser costs money. The umpire costs thousands of dollars. Mediation is way better. And that's what it's come down to. You know, there's a statute called 627.7015 that talks about mediation versus appraisal. And it specifically says appraisal is time consuming. It's expensive. It's costly. It's adversarial. We prefer mediation over that. But no one talks about this statute. No one even discusses it. Unless you practice law in this field, you don't even know about it.
Right.
Right. I learned from the defense side, going through my years of experience, that I've seen good attorneys use that statute to their advantage. Just like they use the matching statute to their advantage. A lot of people don't know that the matching statute requires insurance companies to replace your entire roof. They can't replace your roof and make it mismatched. They cannot do that. There's a statute that specifically says that. The percentages are irrelevant. The percentages are irrelevant. There's a matching statute says that if they do a repair and it causes a mismatch with the undamaged areas, well, they got to repair everything to make it match. Insurance companies don't want you to know about that. Their adjusters never use the statute when they adjust a claim. When you take their depositions and you show them the statute, they get all squirrely and be like, yeah, I use it. Yeah, I use it. Well, how did you use it? Show me your estimate. How you use the statute? Okay, maybe I didn't use it. Well, you know you were supposed to use it, right? Because it says right here, it applies to all first-party claims in Florida. Maybe. I've never seen the statute before. Okay, can I take a break real quick? And then, about like, the depo's finished and they're talking about settlement, a couple of days later,
Absolutely. Right.
As long as you understand these concepts, and the only person that really knows this stuff who's been practicing in the game for a long time. If you just come into this and you don't know the defense side, you're doing a disservice to your client, and that's why I'm not really too worried about these statutes, is because as long as the bad faith statute's there, the matching statute's there, I'm good.
Well, you're good as an attorney, right? But you're good as an attorney, which is great, right? Great. But as a restoration contractor, we have to, I feel at this point, like we have to play the game slightly different. We have to get much more upfront buy-in from the homeowner. Like it literally needs to be a team effort. And this is where I believe now more than ever, transparency, real communication, pre-framing what they're about to embark on. And I think, and I've said this before, and I know that I don't make a lot of friends when I say this, but this is an industry that's created a lot of weak salespeople, generally speaking, because it's always been big old smiles. Don't worry, we'll take care of everything. Sign here, because you knew you were going to get your money. So the necessity for true communication and to walk your prospect, your customer through what has the potential to happen was never really important. But I feel that under today's landscape, it's more important than ever for you to sit down with your customer and explain step by step. This is everything that we're going to do. This is how we are going to document everything. However, these are going to be some of the hurdles that we face. And this is where I believe in the current landscape. I think that it would be intelligent for all restoration contractors out there to start getting a secondary type of testimonial, a testimonial from your customers who went through the battle and say, you know what? so-and-so sat me down right at the beginning of the claim and they explained everything that was going to happen with my insurance carrier. And sure enough, it happened. And have those different set of testimonials that are geared towards justifying that narrative that you're presenting to the customer. So that way they know what they're about to get into. Because again, the documentation is getting stripped away, rights are getting stripped away, and it's making it harder and harder for contractors to, collect on the money that, quite frankly, we're just simply owed.
Yeah, and I agree with you. They targeted roofers, contractors. They targeted homeowners. I mean, they targeted anybody that made the insurance companies feel uncomfortable, made insurance companies actually do their job. They targeted those people. Unfortunately, the Department of Financial Services, the Florida Office of Insurance Regulation, Patronus, DeSantis, they really are in the pockets of insurance companies. And everyone has to understand that. So now restoration companies, really, you guys have to be on the same page as homeowners. And I tell this to every restoration company owner, anyone, make sure that the homeowner agrees with your bill. Try to get a resolution. If not, you're going to have no recourse. No recourse. So yes, it sucks you don't may have direct recourse against the insurance company, but you're now going to become more of a hero to the homeowner. And you, like you said, I like what you're saying. You have to now, make them comfortable, make sure that they are part of the process for you to get paid. And the reality is that really a bad thing? I mean, good and bad. I do feel bad if you have an unreasonable homeowner that's, screwing a restoration company. But I think if you really did the work, and they like you and you did the good job, they're gonna say, like, get my company paid. They're gonna be like, what are you doing? They help me out. Like,
Exactly.
They're not gonna tell you to screw them if you're helping them out. Right.
Exactly. And this is why you also have to have that gut, right? As a restorer in any kind of business, right? Even as an attorney, like, you don't want to take anybody who comes your way. You're always going to have those problem clients. So if you have the ability to kind of vet them before you get into bed with them, like, that's typically the best idea. So Ali, listen, if someone who's listening to the show, they're watching the show right now, if they want to, learn more about you, they want to learn more about your firm, they want to go ahead and have maybe some additional questions, what's the best way for them to go ahead and reach out to you?
You can email me. My email is Ali, A-L-I, at the KRFirm, like lawfirm.com. Ali at the KRFirm.com. My main line is 407-501-4833. My name is Ali A Kadir. I'm on LinkedIn. I'm very loud on LinkedIn. So you can see exactly what I feel, what I do. I'm an open book. The name of our firm is Kuhn Rasovich. The website is www.thekrfirm.com. So you can always check me out on the website, check out the firm. And
all of that information, by the way, Dominators, is going to be in the video description as well as in the show notes below. So that way you don't have to go ahead and pull over the truck or anything like that. All the information will be in the video description as well as in the show notes. But Ali, listen, man, thank you so much, brother, for taking time out of your busy day. We appreciate everything that you're doing and how you're helping out the restoration contractors out there and the homeowners that are getting railroaded on some of these claims. And remember, Dominators, as always, hustle, hack, dominate. I will catch you guys on the next one.
You've been listening to Restoration Domination, your #1 resource for tips, tricks, and hacks to help your business grow. Subscribe to our channel and follow us for more Restoration Domination. And follow our host at Rico Garcia Jr. on Facebook, Instagram, TikTok, and LinkedIn. Till next time, this is Restoration Domination. Hustle, hack, dominate.